So dear participants, first I'd like to welcome you and thank the World Association for Medical Law for organizing such a magnificent conference and event, and also inviting us. My today's topic is the obligations and the rights of a psychiatrist. The legal relationship, the treatment relationship, including a psychological treatment, has a special character, since it is possible that one of the parties of this relationship, in other words, the patient, has a mental disability. And in this presentation, I'll first begin by discussing the legal nature of the relationship between the patient and the physician, specifically the psychiatrist or hospital. And secondly, on the basis of the conclusion reached under the previous question, I'll deal with the question of how it is possible to conclude a contract, a treatment contract, or enter into a legal relationship with a person having mental disability. And my third and final question posed will be, are there any specific obligations or rights of a psychiatrist or hospitals or the changes in the scope of their informs to provide information, their duties to provide information and take the informed consent. To start with the first point, the legal nature of the relationship between the patient and the physician or hospital will be depending on the characteristics of each different case. If the patient applies to a private or a public hospital, then the legal relationship between the patient and the psychiatrist will be a tort, and any dispute will be settled by practicing the tort law principles. However, if the patient is brought to a public or a private hospital or a private clinic of a psychiatrist unconsciously, then the legal nature of the relationship between the psychiatrist and the patient will be an acting without authority. And finally, if the patient applies to a private hospital or a private clinic of a psychiatrist consciously, then the legal nature of the contract will be a treatment contract. Will be, between the patient and the psychiatrist or the private hospital will be a treatment contract. As regards the question, what is the legal nature of the treatment contract, there are three different views in civil law systems, civil law countries. According to the first view, a treatment contract has a characteristic of sui generis contracts, since the treatment contracts cannot be explained or categorized with one of the contract types found in the Code of Obligations. For as much as although the treatment contract is a synallematic one, contrary to the patient's debts, physician's debts cannot be qualified as goods or worker services. In addition, the consequences of any physician's malpractice can be paid with the life of the other party. In other words, the types and the results of the debts are different. The second view claims that a treatment contract is a contract of employment. Austrian and German doctrine and practice are in particular based on this opinion, and according to this approach, the obligation undertaken by this by the physician or psychiatrist is the treatment of the patient, which constitutes a performance of a service. However, from my point of view, a treatment contract cannot be regarded or classified as contract of employment by the reason of two arguments. First, the parties of the contract of employment are employer and employee. However, in treatment contract, neither is the patient is an employer, nor is the physician an employee. For as much as the physician doesn't treat the patient in a manner of in a manner which the patient treats the patient in a manner which doesn't comply with the patient's decision, instructions, or orders. On the contrary, the physician has an instructing role in this relationship, as he or she has the right to determine which drugs should be given to the patient, how many days should the patient stay in hospital, or to determine the appropriate nutritional plan, etc. And second, one of the primary elements of this contract of employment is the duration of the contract. Although it can be decided for a definite or indefinite period of time, the duration of the contract should be foreseeable at the time of the conclusion of the contract. However, in treatment contracts, the duration of the contract will be depending on the patient's individual condition. And according to the third view, actually according to my view too, the treatment contract is a contract of mandate. According to Turkish and Swiss law of obligations and actually code of obligations, a contract of mandate is a contract whereby the agent undertakes to conduct certain businesses or provide certain services. In other words, the agent in contracts of mandate, the agent doesn't have to be the representative of the other party. And in treatment contracts, the physician or the psychiatrist undertakes to conduct a certain services, namely the treatment of the patient. And therefore, treatment contracts should be regarded as contracts of mandate. Coming to the second point, the answer of the question how it is possible to conclude a treatment contract for psychiatrists will be depending on the patient's own individual condition. If the patient has a power of judgment and therefore capacity to act, then the treatment contract can be concluded without any need of any subsidiary element. However, if the patient doesn't have the power of judgment and therefore capacity to act, then the treatment contract cannot be concluded without either the consent of the legal representative or with the court decision. It should be also underlined that if the treatment contains a restriction of freedoms, then a court decision will be mandatory for both the private clinics of the psychiatrists and also the psychiatrists working in a private or a public hospital. Coming to the third and final point, there are 4 duties of a psychiatrist towards the patient having more special character than the duties of other physicians. First, obligation of diagnose and treat patient. Second, the obligation of or duty to provide information and take the informed consent. Third, duty of loyalty and care. And fourth, duty to respect confidentiality. Starting with the obligation of diagnose and treat patients, this obligation is the main obligation of this relationship. In order to treat the patient, the disease has to be diagnosed. And the psychiatrist should choose the method having the high success but the low risk. However, the problem with the psychiatric patients is beginning with taking their consents, actually. If the patient has a power of judgment and therefore capacity to act, then the psychiatrist may provide information directly to the patient and take his or her informed consent, and there will be no problems arising. However, if the patient doesn't have the power of judgment and therefore capacity to act, then some problems will arise. The most significant problem arises while treating the patients who require an inpatient management and also do not have the power of judgment and therefore capacity to act. The fundamental rights and freedoms of the people are protected primarily by the international agreements such as European Convention on Human Rights and also the constitutions. However, in this situation, the patient is treated without taking his or her informed consent, and also additionally his or her freedom is restricted. A psychiatric patient may require an inpatient management due to 2 reasons. First, he or she may be dangerous, and second, he or she needs an inpatient management in order to be treated. To start with the dangerous patient, a dangerous patient tends to damage his or herself or another third person while spending his or her social life. But a question, is there any concrete criterion while identifying such a tendency? Actually, no. Therefore, all concrete cases have to be interpreted individually. However, if a patient attempts to suicide during or before the treatment, or if he or she has the suicide ideation, then he or she has to be interpreted as having a tendency to end damage. It should be also emphasized that it doesn't matter whether these suicide attempts are suitable for that or not. In a case in the USA, the patient attempted suicide 18 times beforehand and was successful at the 19th one. And the psychiatrist defended himself by relying on these 18 unsuccessful suicide attempts, which were actually not suitable for that. And the court found the psychiatrist guilty as he had a gross negligence in the instant case. And in Germany, it is accepted that the psychiatric patient has a tendency to endamage him or herself if this psychiatric patient doesn't take the pills which are of vital importance for him or her. Coming to the patients needing the inpatient management in order to be treated, these patients are the patients who doesn't comprehend the significance of the treatment administered for them. And in both cases, the psychiatrists have to take the court decision. Let me now turn to the second duty, which is duty to provide information and take the informed consent, which is basically the aims of establishing the trust relationship between the patient and the physician, and also to make the patient able to decide whether he or she wants to, wishes to accept or refuse the treatment. And therefore, it is significant to provide information to the patient on diagnosis, treatment process, risks of the process, and the financial frame of this treatment. It is controversial, according to the doctrine and practice, whether there's a duty to provide information and take the informed consent during psychotherapy, as there is no interference with the patient's physical integrity during psychotherapy. According to my opinion, a psychiatrist has such a duty as there is a risk of unsuccess in the end. Pursuant thereto, during the Osherov case in the USA, a psychotherapy treatment ended unsuccessfully, and the patient alleged that his psychiatrist did not fulfill his duty to provide information and take the informed consent. And if he had done, then the patient would have chosen medication instead of the psychotherapy in order to reduce the treatment costs and also recover his health faster. And the court and the patient claimed all the psychotherapy expenses, and the court decided in favor of the patient. Now, duty to respect confidentiality has a more special character than for psychiatrists than the other physicians, as this branch is interfering with the patient's life. And therefore, examination findings, personal status, sexual preferences, or the other private information should be preserved by the psychiatrist. Very good. Likewise, duty of loyalty and care has also a special meaning for psychiatrists, especially for the issues of the doses and the exposure time, as these drugs may cause addiction. And second, the patient's suicide attempts. And third, the patient's isolation, if the patient has a tendency of damaging his or herself or another third person, if the patient is dangerous. I think I'm going out my time, so I'm wrapping up my words in just 1 minute. Coming to the rights having a special meaning for psychiatrists, I think there are two rights having a more special meaning for a psychiatrist. Physician's right to refuse a patient and treatment, and second, physician's right to treat without concern in emergency cases. Consequently, the relationship between the patient and the psychiatrist has some distinctness from the relationship between the patient and other physicians, and this distinction is distinguished from the, especially in obligation of diagnose and treat patients due to the loyalty and care, due to respect confidentiality, and also due to provide information and take the informed consent. I thank you for your patience and attendance.